Due to the fact that this is a recorded meeting, I want to go around and have everybody introduce themselves at the end, so we've got it on the recording. And then we'll move on to agenda review and announcements. I'm the moderator, Bruce Huloff, Director of the Auto Industry Division.
Chris Rouse, Auto Industry Division. Mr. Perkins is concerned because there isn't a microphone, so I'm just going to tell him real quick. The recording device that they're using should pick up the whole room, so we don't have to have the mics in front of us.
Okay.
I saw the look of sheer panic on your face, yes, so sorry.
Talking to the water bottle.
Yeah.
John Shendon, former dealer.
Todd O'Connell, CIADA Used Car Association.
Mike McKinnon, CIADA.
Michael Domermuth on behalf of CADA.
Tammy McCoy, CADA.
Mary Marvin, CAPS.
Steve Perkins, used motor vehicle dealer and former dealer board member.
Rick Weinkoop, Weinkoop Law Office.
Randall Cherry, Attorney General's Office.
And for the record, Matt Heap from the Auto Industry Division will be joining the group in a few minutes. Agenda review and announcements. I sent the agenda to everybody a few days ago. We can look at that real quick. We'll do a quick review here in a minute or two of the last meeting, the topics of discussion. Today's working group, the meeting scope will be the discussion concerning financing and guarantees, general discussion and review of the group members' suggested revisions to Form 2434, discussion about embedding Form 2434. If that happens, it will require new language for the regulation. And then a couple of holdovers, should interest rates be consistent with the finance agreement on 2434, if we leave it in there. Should timelines and rates be consistent within the contract and the disclosure form. And at the end, we'll do a next meeting update and any other needed input. I'm committed that we will be done no later than 4. I'm committed that these meetings will last no longer than 3 hours. I'm also committed that as close to the top of the hour as I can get to within the group's discussion. We will take a 10-minute break at that point in time. One of the things that, for the record, that I probably need to go over every time is that just the general guidelines, only the working group members may participate in the discussion. If there is public comment, the public is invited to this meeting, and if there's public comment, that will come at the end of the meeting. The agenda, the discussion will be strictly enforced to ensure that we'll be able to cover all the topics. We ask everybody in attendance to be respectful of each other in the process, and again, remember this meeting is recorded. And please speak as clearly and concisely as you can so we get a good record. I am going to send around every time a working group signature document, so we have that for the record, and if anybody from the public shows up, I will have a signature page for them. Questions on announcements or process? Seeing none, hearing none. Review of last meeting's topics and discussion. This is the second meeting of Group 1, Priority 1, having to do with 12.6.104.3K, motor vehicle regulation, 12.6.504.1MI, which is the power sports regulation, and that is Form 2434. Additionally, this group has been charged with looking at 12.6.118.3B, which is the rejection of financing regulation in the motor vehicle side, and 12.6.523P, the rejection of financing regulation on the power sports side. I want to go back to announce the one thing on the announcements before I talk about what we did last time. We do have, and I committed to this group and to the board and to other people, that all of this would be on the website. We have built a place on the website for announcement of this meeting, the agenda, also the minutes and the recording. I do not want to, we have had a little bit of difficulty with the recording, and I'll explain that. I do not want to post the minutes. I want to post the minutes at the same time we post the recording. The minutes are very, very general. in nature. They are a 30,000 foot, look at what was going on because the recording is there. What we are having a little difficulty with is how to post the recording. There's a way to do it. OIT, the Director of Communications, that's the way that it has been done with a couple of the other divisions, but there is a concern and/or a concept that there's a better way to do that, way above my head. But we are working with the Director of Communications of the Department of Revenue, how they want these types of recordings posted. We put that request out about 4 or 5 days ago, and we are still waiting how they want us to post the minutes, or how they want us to post the recording, I'm sorry. It is there, ready to go. It's just a matter of how it's done. So going back to looking at what we did last time, in real general terms, we talked about Form 2434. There was some history that was talked about. There was a lot of good, lively debate that took place on the form and what is on the form and what is not on the form, and is there a statutory conflict between Form 2434 and Statute 61708, the Consumer Protection Act. There was a lot of good debate on that. I think at the end of the meeting, or towards the end of the meeting, there was a general agreement that the form does need to remain in some form. There was general agreement that, especially, I think it was E on the form, might need some clarifying language, perhaps D on the form. And there was general agreement that, based upon, I suppose, my wish is that Form 2434 be unembedded out of the regulation. And if we accomplish, if we can get to that, that will require, obviously, that language is added to the actual regulation. And whether or not that points to Form 2434 specifically, or that points towards the board approving a form, like many of the other statutes do in our organic statutory scheme. So we talked about that. At the end, there was a discussion about group members submitting proposals for rewording of Form 2434 or any other proposals. That was the general discussion from the last meeting. What has transpired after that meeting is, I believe Mr. Weinkoop sent in a proposal, Ms. Marvin sent in a proposal, Ms. McCoy sent in a proposal on the form, and I believe Mr. Dommermuth sent in a proposal / kind of position statement on guaranteed financing or financing and guarantees. So that's where we will begin the discussion today on those documents that were submitted. And the first one on the agenda, we don't have to take it quite in this order, but I do want to stick to the agenda as close as we can, is if Mr. Dommermuth would like to talk about his submission, which I believe I emailed to everybody yesterday, I think. I think I got it from Mr. Dommermuth the day before, I believe. I think I emailed it to everybody yesterday. A document dated January 26th, and sort of a position statement or an opinion on financing and guarantee. And I'll turn the floor to Mr. Dommermuth to...
Just very, very briefly, Bruce, I prepared that because I sensed a strong sentiment at our last meeting that the moment a retail installment sale contract and purchase agreement is signed, financing is guaranteed. And I don't think that's the case. I think the documents speak otherwise. I certainly recognize there are circumstances where a dealer might make oral representations that constitute a guarantee of financing, but I can tell you from the paperwork that I'm familiar with, the contracts that I'm familiar with, the contrary is true. And as Mr. Wingcoop pointed out numerous times during our first session, there are conditions subsequent, and if those conditions are not satisfied, the contracts can be canceled, which is contrary to the notion of any guarantee. And the main reason I wanted to get that out to the group before we met again was, I think there's a definite need for 2434. And we need to educate consumers about spot delivery, how it works, and what's supposed to happen. But if we start to go down the road of, well, financing is guaranteed, I think we're not serving consumers or dealers very well. Because I think the contracts that they sign have specific language dealing with the issue. And I wanted this group to see the typical language that's in both the sale contract and in the retail installment sale contract. So that language I quoted is from the Bradford Publishing documents, but I know the Reynolds and Reynolds law contract has, which is another version of the retail installment sale contract, has similar right to cancel language in it. So that's why I prepared the memo. I wanted people to see what the contract language was and make my position clear on financing guarantees.
I like that line you put in, seller does not guarantee financing. I mean, it's just one more affirmation of what we've been talking about. And there was not a lot of, I didn't see tremendous differences in a lot of the language between all of the examples that were sent out. One of the things that, there are a couple of things that came to mind is dealer must notify you within 10 calendar days, or do we want to have 10 working days? Because if somebody sold a vehicle on a Friday night, that would give you 5 working days, even though it's going to be a 9 or 10 day period. So I think that clarification has to be made. Is 10 calendar days enough, or should it be 10 working days?
The current regulation, John, is 10 calendar days.
Right.
And so that is the current law in Colorado.
And I'm just throwing it out, does it make a difference to anybody in this room from where we are today?
I'm thinking that it doesn't even need to be in there, because if that changes, and then it changes quite a bit with the dealers and the associations and the dealer board, if that changes, then you've got to change the form again.
Right.
The time period, so.
Again, I have no issue with, I think it's got to, something has to be in there with the 10 days. I agree with that. It's just a question, is it going to be calendar or working?
Yeah, and just on the general point, it seems to me it would be good to put it in there because people just don't know it. And so often we get the call, the dealer's telling me that my financing didn't go through, and can they really do that? And don't they have to, or don't they have to tell me before they take the car, kind of thing? So I think it would be important to put it in the verbiage, changing the regulation on number of days. I know we had some discussion at in the earlier process on this, and I think you had even alluded to the fact that originally part of the intent there may have been a time frame from when there was notice from the lender. Was perhaps the original intent at some point, that it was from when there was notice from the lender, and then it could potentially even be a shorter time frame, frankly. Because doing it from the date of the contract doesn't allow for that, the time period it may take lenders to go and the person to jump through hoops to get financing finals.
And I got no problem.
I just remember that issue.
I have no
came up
problem with
last
the
one.
way it is, 10 calendar days. I mean, I don't have a problem with bringing that up because that's always a discussion around that 10-day period when you get a group of dealers.
Was it at the same time that we changed it, that we plugged in the 10 calendar days? When did we visit that regulation?
That was,
Oh,
yeah, that
It's
was
been a long
later.
time ago.
Well before my.
Because, it started out that it was 3 days,
Right.
and then went to 7 days, and then went away, and then.
But 10 days was 7 or 8, 2007, 2008.
Exactly.
Certainly a technology at that time we didn't get callbacks from banks quite as quickly as we do today. Technology, we can get a callback in seconds, virtually. If somebody's qualified, it's electronic and we get it that quickly. So, you know, and I'm good with 10 days still.
Yeah.
More difficult underwriting takes more time.
Right.
And so, and calendar days is just simpler for everybody. And nobody has to worry about
I agree.
holidays or,
Are they open today?
are they, yeah.
The other issue here was it says that the dealer shall promptly return any deposit, including any trade-in vehicle. How about the dealer and consumer? I mean, the consumer's got to promptly return the vehicle. Something should be put in there where the consumer's got some liability also as far as getting the vehicle back, if the deal is canceled and so on. It can't be just the dealer shall promptly return the deposit or the trade-in. There's got to be some liability also to the consumer signing this form saying that I will promptly, or both parties will whatever. I mean, you can't write it one way and not the other, in my
The
opinion.
way we did it on one of our new car dealers, we did it 24 hours. At 24 hours after they're notified, they have to return the vehicle.
I'm not sure the dealer board can promulgate any
Well, no.
regulations that would bind the consumer to anything. And if you got it in the buyer's order, that's fine.
Right,
But
I'm
saying
just
on
giving
this
examples as far as
document,
24 hours.
The dealer board can regulate dealers, they can't regulate consumers.
But it sets up the ability then to say.
It's not regulating anything, it's just saying that they'll promptly return it. I mean, which the dealer's saying that they'll promptly return a deposit in the trade. Does the consumer have a liability to return the vehicle?
Yeah, there's always civil court.
But there's no, it's notification to the consumer that if you don't return it within 24 hours, if we're gonna charge bailment, understand, that's gonna be one of the conditions that we're gonna start charging bailment right away. Again, whether there's usage all the way down the line or not, but that could be a prerequisite saying if you don't return within 24 hours, then if the bailment wants to kick in, that could be the time that it kicks in.
And again, you know, if it's in the buyer's order and they've, you know, it's contractually agreed to that, you know, we're gonna charge you repo charge if we gotta get the car, whatever. I'm just talking about this board's authority under statutory regulation. I don't think they can put any language in there that's going to bind a consumer. You must do this. What authority does the dealer board have over a consumer? They can't tell the consumer they gotta do anything.
But isn't an agreement between two parties that they're both gonna be responsible?
Well, because again, this goes back into the buyer's order, so it's contractual.
Well, but you
Well,
could
that's
just
what-
say
but
you
we're not
may,
talking-
the consumer may, but, you know, it's governed under the terms of the contract.
If the
So
consumer
this is a
fails.
disclosure to the
if-
consumer, right?
I'm sorry, Tim, I interrupted.
No, go ahead.
If the consumer I think don't wanna put words into Mr. Weinkamp's mouth, but if the consumer fails to return, and it's part of the contractual type of agreement, certainly certainly the dealer would have civil remedies. But the board, Mr. Weinkamp's absolutely correct, the board has no ability to hold any consumer to any level of responsibility.
But we're not talking about that, we're talking about trying to get an agreement that both parties obviously agree to. We're trying to make it as clear as we can to avoid civil litigation, which takes time and money and everything else. I mean,
God bless it.
well, I know there's a few people that depend on that, but isn't that part of what we're trying to do here, is make it very clear, very distinct, what both parties have agreed to, and try to make it so that it's legible, easy to understand, and
But,
Well,
you
just
know,
to
but
jump in on that,
here's
though,
the
just to
problem.
jump in on that, John, I would say, we're not trying to make an agreement here, we're trying to give clear disclosure of what may be in
Clarity.
the agreement they did
Right.
sign. And so, you know, if you
That's
say
why
too
I-
much, that may or may not be what
No, I
you agree
understand,
to.
but that's why I like the part that it says, you know, there's no guarantee of financing. I like the part that says 10 calendar days. I mean, these are very clear, distinct, so both parties understand what the agreement says. This, again, is an agreement between two parties.
again, here's the problem. This is the sort of one-size-fit-all, this goes with every sales document. resale, retail sale.
Right.
We don't know what the contract between the dealer and each consumer is gonna say. What contracts you might wanna use might be different than what contracts Mr. Perkins wants to use. And so you can't put in there what's gonna be in the underlying contract, because there is no standard underlying contract. So everyone might have different terms to their sales contract. So putting in to this document, the disclosure document, you've agreed to in this contract, it doesn't really work, because everyone's free to make whatever contract they want.
Well, as it reads now, it just says that the contract may require you to immediately return the vehicle. So, yeah, I agree with you from that standpoint, but there's nothing that says that there can't be something that, once it's incorporated back into the buyer's order, doesn't give the dealer ability then at that point to say, if you haven't complied with our buyer's order. And I understand where you're coming from, and I see you're saying, hey, guess what? You can't put the board doesn't have jurisdiction over individuals. So if we put it in this form, they can't enforce it, I agree, but the dealer can still enforce something that comes out of this form because it's now in their buyer's order.
And I'm sort of less is more when it comes to this. I mean, there's certain statutory things that have to be in this contract or in this disclosure form. And if it's not in the statute, that it's gotta be in there, like, you know, for example, in the present one, it's got, you know, repossessing charges will apply and stuff like that. That's not in any statute. I mean, that was just added ultra virus, I don't know how, I don't know why. But, you know, if you're gonna make a clean disclosure document, I think the less you put in there, the cleaner it is.
One of the things that we did is we jumped ahead to Form 2434 without a little bit of discussion on guarantee of financing. I guarantee Mr. Donovan's position and what that means. One of the concerns that I have is we have two terms that we throw around here, is down payment and deposit. I'm not an attorney, but I think those are two different things in this industry, two totally different things.
What's the distinction?
The down payment is money that goes towards the purchase of the vehicle. Deposit is holding the vehicle for a period of time. Those are two different things. And what little bit of experience I have with the Court of Appeals recently, well, Court of Appeals is gonna go right back to, if it's not defined in the statute, they're gonna go back to Webster's. If you look at Webster's, those are two different terms.
Could be or.
They.
Well, 61708 talks only about down payment.
Right. But is that not a timing distinction? Is the deposit before the sale takes place and the down payment subsequent to the sale taking place? And so it depends on when in time the where it is.
Well, yeah, I mean, I can give you a deposit on a new Corvette, right? This is, you know, whatever, pick whatever hot car you want, right? When this comes in, here's 10 grand, I want the car.
Right.
And we don't sign any paperwork, I mean, there's, you know, your usual down payment
Right.
or deposit and all of the
Right.
thing. And then when it comes in, if it's the right color and it's got all the doodads that I want on it, then we sign a contract and that, you know, okay, now give me back my deposit and now I give it back to you as a down payment. And those are two separate things.
So the deposit in that scenario could become the down payment, but until that car arrives and there's another meeting of the minds or another agreement, it is a deposit.
And the second that the documentation is signed, it becomes the down payment. It's no longer a deposit.
Yeah, there's
It's
no
a
checks
giant-
transferred back and forth, it's a general rule.
Yeah, I mean, theoretically, you could, okay, you give
Right.
it back and then I hand
Right.
it back to you,
Right.
but it's really two separate transactions.
So if you put the word or between the two, does that take care of the issue? And I'm not, I have no idea legally.
Well,
Depends on what the definition of or is.
That's
And most buyers
Is that
owners.
like is?
Most buyers owners only buyers orders only say down payment. I've got a few of my dealers that say down payment / deposit, so I look at buyers orders and say, okay, clearly it's a down payment, so that's where we start from.
My concern is that this group and the Motor Vehicle Dealer Board have no authority to write a rule, we all know this, defining 61708. But 61708 is a very, very powerful statute, and it uses the word down payment.
And nobody here disputes that if a dealer guarantees financing, they have an obligation to return the consumer's down payment. But that doesn't need to be in 2434.
Say that again.
Only if they made a guarantee.
Nobody here disputes that if a consumer or if a dealer guarantees financing for a consumer and is unable to procure that financing, that dealer must return that consumer's down payment. That's the law in Colorado. That's in the Consumer Protection Act, and if you don't do that, Mr. Wingcoop will be at your dealership the next day. But that doesn't need to be in 2434 because it is not a document establishing that financing has been guaranteed.
Well,
See, that's the whole reason I wrote the memo, is so we can avoid this whole confusion about financing contingencies and guaranteed financing.
well, here's the thing, this is what I keep coming back to. You could basically, I won't say I don't care, but for the purposes of what we're doing here, how do you want to word that, condition? I don't really care, all right? I mean, use whatever you want in there. Whenever someone signs a retail installment contract, they're financed, period. And that's the Truth in Lending Act says it, the Code of Federal Regulations says it. The deal is consummated, financing is consummated, regardless of the creditor's participation. And that's something that, I just beat on you guys left and right, no one gets it. The dealer is the creditor.
Well, if the financing is a done deal, then it's not guaranteed, we're way past that.
It's absolutely guaranteed. You have financing.
See,
You have
It's a done deal, is what
financing
you're
with a
saying.
condition, okay? And if you want to exercise that condition sometime down the line, okay, great. And that's fine, unwind the deal. But once you sign the retail installment sales contract, you take it out of the bailment issue, right? At that point, bailment's done. You've got a consummated finance contract. That consummated finance contract may contain a condition, but you still have a consummated finance contract. There's no other way around that under the Truth in Lending Act. So put in whatever you want in there. I don't really care that much. I mean, obviously for.
Well, so a consummated doesn't mean that it's going to be finalized, and it doesn't mean that it's guaranteed.
No,
They're
it
two
is,
very
it
different
is
things.
financing. See, here's the
You
thing.
can make that argument, but that's your
Well-
legal opinion.
Yeah, I can make that argument and so can the Federal Reserve Board. I mean, I'm not just pulling this out of thin air. This is CFR 226, right? I mean, it's, consummation occurs when the consumer signs the contract, regardless of the creditor's level of commitment. Period. I mean, that's what it is. You've got a consummated finance contract. Now, that contract may contain a condition subsequent that if we can't sell it, we're gonna unwind it. But once you have that consummated finance contract, per 61708 and, what we're talking about here, well, you've got a guarantee of financing.
And see, I disagree.
Yeah.
Okay.
I mean, because it can be canceled, it is by definition not guaranteed. I mean, and you will never get me to where you are. I mean, if you're trying to get us there, you're wasting our time and everybody else's time here. We're not going there.
No.
And Bruce, that's why I wrote the memo, so you could see what the language is in the contracts that are signed by consumers. So
Here's my.
Go ahead.
Okay, here's my problem with, and it's not my problem with the memo, because that's your position.
Right.
Okay, my position is for the unsophisticated consumer, okay? So you put language in this disclosure form or in this contract that says this isn't guaranteed. A dealer puts that in there and says it isn't guaranteed. But a dealer practices every other thing that says it is guaranteed, everything else. You put a temporary tag on it, you throw them the keys to the car, you say, congratulations. You sign, you sell them and charge them a warranty. You etch the vehicle. Okay? You require them to have their insurance on the car, but you're saying it's not their car. But you require them to, when they drive off the lot, it's their insurance. So they go out and have an accident, who's covering the car? Because if you're not guaranteeing financing, you're not guaranteed that it's a sale. It's the unsophisticated, which there are a lot of people out there, including Bruce Zuloff, a little more sophisticated today than when I was appointed to this position, obviously. That's the person that I'm here to protect.
I think that's what we're all here for. And it is impossible, if that's an expectation, that is so Pollyannish, we'll never develop that. We can't dummy-proof everything that we do here. John spoke to Bradford Publishing and Reynolds and Reynolds, right? Both of these installment sale contracts go through tests, state tests, to be conforming and compliant to state laws and truth in lending. And all of our banks that we assign these contracts to regulate and control these contracts, including credit unions, if they're valid and can be upheld and speak to what's legal in the state of Colorado, and I presume other states. We don't just get to randomly assign any contract to a bank and say, oh yeah, that's good. They're controlled by all the regulators, and they've been cashing these contracts with this language for the 40 years that I've been doing this. So clearly there's been some other eyes on all of this to say, yeah, it's cancelable. Yes, and do we know that some dealers say, yeah, it's guaranteed? Well, then hang them by their ears and find their butts.
The other thing is, if everything was guaranteed, there'd be no need for this provision in the first place, referring to an oral guarantee that leads to a good faith belief that financing is certain. I mean, if everything was a guarantee just because you drove off the lot, we wouldn't even need this.
And talk about statutory charges, 16104E talks about if financing is not approved. I mean, it's in the statute. You may not like spot delivery, Bruce, but it's permitted by statute.
You know what I don't like, is I don't like King's X.
You know, like what? I'm sorry.
King's X. And I can line up hundreds of people that say, that was, the salesperson told me that was my car.
That person's been guaranteed financing.
That person's been guaranteed finance. And I don't, and is it an education thing for all of your salespeople that are in the business? Perhaps, but that's happening every single day.
But that's why the salesperson doesn't kiss off the customer. We have other people that finalize the deal and say there's, nothing, everything's gotta be in writing. This is. I mean, that's how
The
you run a
F&I
business.
person.
That's right.
Had one yesterday, John, one yesterday.
So
Not
it's
exactly
either
the
bad
same.
F&I
I understand,
You know.
but I understand. It doesn't matter what I say, it matters what the board says, okay? But I'm in a position that I have to look at I have to try to take the other side of this within this balance thing.
Well,
okay?
but are you looking for 100%?
Sure, I'd love to.
Well, I understand that, but I mean, is that 90%, pick a figure, what are the percent of the contracts that go through the first time that you?
Dealer arranged financing is now about 80% of the industry,
Okay.
up from about 40% 20 years ago.
Okay, but I mean, those that go through on the first contract that you
No
write,
problem, yeah, 90%.
90% or 95%. So we're not talking about 100%. We're talking about 5% of the people that are saying, I didn't understand, or I don't get it, or I don't know, whatever reason there is. And there are some bad dealers and there's some bad finance, I understand all of that. But that's not the vast majority. When you're dealing 95%, that's pretty good. Is there a problem with saying the seller does not guarantee finance on this form?
I don't think you need to.
That's not a matter of needing, you don't need the form.
Why wouldn't you want that on the form?
Well, I think the whole purpose of the form is to try to raise the level of awareness
Right.
because of
But if
exactly
it's-
what Bruce is saying.
If it's one more line that
And
says,
that is why
we
we're
don't
here, is
guarantee.
to just make sure you know your rights, make sure you look for this, make sure you look for that. I mean, to me, that's the purpose of the form.
You can put all this stuff on a form, and I'll guarantee you that 5% doesn't change.
So
And I
why
think
is
that's-
it so important that a dealer have assigned risk? I mean, I'm not knocking, spot delivery. Spot deliver all the cars you want, that's fine. Here's the purchase order, here's your disclosure document. Take the car, when we get, fine, we got all your credit information. When we get final approval on financing, we'll call you back. And then you charge $200, $300 a day, knock yourself out. I mean, that's easy. Spot delivery with a purchase agreement and a disclosure form and a filled out credit app. And you wanna do that, send someone out and say, here's gonna be your finance charge, $200 a day. And then when we find out from whatever credit union or bank, what the terms are, great, we'll bring you back in.
Both
That's not
sides,
industry
both
practice.
sides are engaging in a transaction and taking certain risks, and both sides should pay for the use, I mean.
No, but
consumers
that's the
should pay for
problem, the
use of
car dealer
vehicle.
has no risk. Once you get that signed retail installment contract, it's payable to the car dealer, so they can always get their money out of the contract. They can sell it to someone, or if they don't like what terms they can get it, and, like I say, I'll buy all these things for $100 a day, you got it, or $100 a contract, bring them on over. They can always sell the contract, but if they can't do it, well, then they get the down payment either way.
If you're not guaranteeing financing, like you're saying, a lot of the time that doesn't happen. Let's go under that premise, okay? Because that's one of your arguments is that they have not been guaranteed when they walk out, right? Regardless of temp tag and all that,
Yeah.
correct? Okay. Then what is wrong with putting in the form that same language? You are not guaranteed at financing. You are taking this vehicle
I have no problem
with the
that.
understand.
I think
I think that's all that we're.
I think that's the purpose.
That's part of what
I
we're
mean,
looking for, isn't it?
I have no problem with that. I mean, I think our dispute is over what triggers an immediate return of the deposit or the down payment, and when can the dealership withhold usage charges from either of those items. And our contention, I mean, I think this is the fundamental issue here, and it's somewhat of a legal issue, and it's somewhat of a what constitutes a guarantee. And I think our position is, and I do not dispute that there aren't people who will represent, oh yeah, you're good. And in that case, they've crossed the line, they violated the Deceptive Trade Practices Act, and clearly the dealer shouldn't be able to withhold any charges. And I don't doubt that everybody who gets to this point is gonna argue that, oh yeah, he told me, regardless of what was actually said. And there's gonna be some of that too, but that's the nature of the beast, right? But if truly there was no guarantee and nobody made that representation and they've signed 3 different disclosures to that effect, then no, I don't think there was a guarantee, and the dealer should have the right. And I know a lot of dealers that typically don't ever charge the bailment. They put it in there, and they typically only charge it when the consumer made serious misrepresentations on their job or their income or whatever it is, and they're gonna take a several $1,000s loss on a vehicle that's now used, that is coming back in, and there's a loss on their side too. And so I just don't see why a dealer that hasn't made the misrepresentations shouldn't be able to cover their losses too.
And I haven't once even insinuated that you're not entitled to that type of reimbursement.
Well, I think that's the difference of opinion.
But are
that
we in
have with
agreement,
Mr. Winky.
there's a lot of that, are we in agreement that putting dealer does not guarantee financing and a couple other words on this form?
I would
That's
think
not a
that would
problem?
strengthen the dealer's position.
Well, I don't think anybody's
I would
not in
agree.
favor of that,
Huh?
right?
Because
No,
then
I
they
think
can't come back and say, I didn't get it, because although the oral representation about guarantee, I know we can disagree all day and all next week and everything else as to whether the temp tag and all that other stuff denotes guarantee. But if you have in writing on this form, it's gonna further bolster that, no, we told them, you're taking this to a certain degree at your own risk, and if you're not guaranteed right now, you're taking this out. And that customer may say, you know what, I'd rather just leave it here until this is finalized. I'll come back in and do all the paperwork then. But, I mean, we could point to that too. Well, no, I know what the salesperson may have told you also, but did you not sign this form? Yeah, well, doesn't it clearly state right here, you are not guaranteed financing right now?
And
I like that.
I see what you're saying. I frankly thought that we had said that, but you're right, we used other words.
Let's
So,
do it.
I mean, I think very clearly finance approval pending, you know, financing is not guaranteed, whatever makes that the most clear up front, I think everybody's in favor of that.
I don't think you can use that with a risk, though. That's the problem. And I mean, that's what I put in my proposal. I left all that language in here. They're gonna arrange financing and stuff
Right.
like that. I also put in, if there's a risk, you don't have E, F, or G. Because you've got a finance contract. It's not a guarantee of financing. It's not evidence of financing. It is financing. It's a finance contract. It has terms. They're enforceable.
So what you're saying, basically, at the end of the day, is if there's a retail installment contract, no applicability here, but you cancel under the retail installment contract, you give the conditions subsequent, give written or give notice of cancellation, boom, we're done, you don't charge bailment, you don't go sue anybody because the
Right.
retail installment contract completely says.
No
that.
damages.
Is that what you're saying?
Yeah.
I mean, in theory, really, until
I mean, the
the
other
deal's
thing is-
done, they should be driving around on a demo plate. No more than 7 days, but, I mean, you shouldn't be putting a temp tag on it. You shouldn't be putting a temp, I know we're not gonna go there,
Temporary.
but if you're
They call
telling
it
me
temporary for a
that,
reason, Matt.
yeah, because they can't get
Because
a
of
per metal
registration.
plate, it's not for the convenience of the dealer necessarily, it's because we
Arizona
can't issue
gives
metal
out
plates.
Permanent plates at the day.
That doesn't
of
work
sale.
here. I know, and that won't work, it could, but it won't for several years. It definitely could,
But
but,
it's again, it's a sale that can be canceled,
right.
okay?
But what I'm saying, you guys are telling me that it's not guaranteed, the financing, when they drive out of the.
The sale and the financing are
It's
guaranteed.
not guaranteed, but we are putting registration documents on a vehicle.
Non-registration, temporary.
Yes, that's a temporary
temporary
registration
permit.
permit. Temporary registration permit. It's a registration
But
document
it's still
of the
temporary,
DMV.
yeah, right, but it's still temporary.
It's in
And
Matt's name if he's the purchaser.
technically, if that is not really a done deal because you're still awaiting approval of financing, it's not consummated yet.
So I don't have
See-
I don't have the language in front of me on the temp permits, I'm not
Well,
quite sure why the temp
It-
permits
there-
are such a big.
It
Mr.
says you shall
Mr.
issue a
Wingfield is
temporary
right.
permit
I'll
on
rarely say
consummation of
that.
the sale of the vehicle.
Mr. Wingfield is right,
Hang
I
on.
rarely say
Check the
that.
recorder.
There is a sale and financing consummated when all the documentation is signed, but it can be canceled. That's all I said.
I'm giving you a extreme, I'm not
But
suggesting that. any of
we're
this
all in
actually
agreement
happens.
that this should say, there's no guarantee of
I mean,
financing.
I would
In
have
fact,
to
the one that.
consult the temp regulations I don't remember the exact terminology in there.
I mean, you
Frankly, we
get
could
caught up
pursue
on
a
the
rule change on that
registration
if we
here
need
is
to.
the wrong path.
We can
to go.
manage the 95%, you'll never manage the 5%.
No, and that's
I mean,
why this is to protect
The
dealers.
5%.
Yes.
That's what we're doing.
Yes.
We're here worried about
I
that.
mean,
1,
by
2,
the
3,
same,
4,
so
5.
by the same token, the dealers collected sales tax and sometimes remitted that, and there's an entire unwind process where they can get a refund of the sales tax that was collected too. So, does that mean it was a final sale?
I mean, we'll spend several more hours if we want to go into what
No.
consummated means, so
I
let's not
agree.
do
Yeah,
that.
So, for consummation, the consummation is not in the deceptive trade practices provision,
No.
is it?
Well-
So, what's in there is that the financing is certain.
It's guaranteed, right.
The financing is certain. It doesn't refer to consummation of the sale, it doesn't refer to consummation of.
Consummation on the temp tag is permits may be issued by a licensed Colorado new or used car dealer, wholesaler, or wholesale motor vehicle auction only upon consummation of the sale. Consummation under the Code of Federal Regulations and the Truth in Lending Act is when the consumer becomes obligated on the contract.
Right, and there can be a consummation of a sale, but the financing can still be pending, and
No.
that's exactly
The
what this
consumer is
refers to.
obligated on the contract. That financing is done. Now,
It's
you wanna
not, if the lender
unwind.
doesn't buy it, it's not a done deal.
No, no, you are the lender. The car dealer is the
Well,
creditor.
And again, you know,
But
it
that's,
doesn't
we could be here for
advance
that.
the
Yeah,
cause for us to have.
we've been down this road, you don't need to go down here.
Would
I mean,
you
but
guys
it's-
spend your
You're not
client's
gonna
money
agree.
and get an appellate case that then we can put this
You're not
to?
gonna convince me.
I mean, the other thing is though, if we pursue a rule on this, the Attorney General's office will chime in on the rule and
Sure.
tell us if it's not allowed.
So,
And we can,
Let's assume 40 years of contracts are okay. Let's assume that.
well, yeah, go back to, when a contract has been amended or changed for use in the state of Colorado. I mean, I'm sure us dealers, I deal with all the major banks in the country that are all federally regulated, Chase, Wells, they send out us bulletins. Bradford Contract X is no longer valid, you have to use this new new contract or they're no good, I kind of go, and I mean, I appreciate your position and your legal profession, but what has changed? What statutory stuff has changed that the division is questioning?
Oh, no, wait a minute, that's not fair, Steve, it's not the division. I mean, the division doesn't question, I mean, we get complaints, we
I
investigate
understand you
complaints.
get, but I'm hearing
That's
that
what
from
we
a
do.
temporary, one of Matt's grant is different. The temporary permit is a consummation of sale, that it's not cancelable or guaranteed. And I think we're all, I shouldn't speak for everybody, the better that we can make this disclosure, right? And we put this out first. We want, we want people to see this from the get-go. Now, we don't spot deliver at my store, so I don't have to. One of the things that we run into, as Tammy alluded to, when a customer signs a application and, says that I make X amount of money, or I can provide X amount of documentation, proof of residency, blah, 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 and, oh, I'm gonna get that all for you, and then a dealer who does deliver that car under those circumstances, and the buyer can't provide all of it. And that's when the dealer gets hurt and should be entitled to the same protection. So there's a lot of stipulations that go with
It works
an
both
approval.
ways,
Yeah, that, but,
Let me comment, Steve, because I really do need to
Okay.
comment. The division doesn't have, I mean, this is not the division bringing this forward. This is, let me try to go back. The division's job is to investigate. That's it, on these issues. That's it, okay? On the rulemaking side of the thing, the division's job is to conform to the statutes that says we've got to review 20% of the statutes or the regulations every year for the board to see. And that's what we're doing. When we put together the first regulatory agenda 2 years ago, this was a hot button topic for investigations, this issue. Okay? We had quite a few complaints. Mr. Weinkoop has defended some clients on this very issue, this very thing, where financing didn't go through and the down payment was kept to offset the bailment. Mr. Weinkoop's position is that's a violation of 61708. He's been successful on some cases on that, okay? The division's position at this point in time is to bring this, to form this group and to discuss it. If this group decides that there is no need to change anything, okay, we take that to the board meeting. Just because there's a rule before you doesn't mean it has to be changed. That's not what the statute says. The statute says it has to be reviewed. That's what it says. This has been a topic of 2 years, okay, from complaints we have. The next group, not the next group, the group after that is the same exact thing. It's things that are going on in the industry. Ms. McCoy and I debate this all the time. Clarity. Right. She wants clarity, and she's not wrong on everything. And she thinks there's gray areas a lot of times, and I don't think there's gray areas. I think there needs to be clarity for everybody, including the consumer. Because I don't think there is clarity for the consumer a lot of times, and that will always be my position on a lot of things. So this is not the division saying that this is broken and we have to fix it. This is the consumers that have complained to us, some of Mr. Weinkoop's clients that have been successful saying, we have a problem here. It is the 5%, Mr. Shannon, there's no doubt about that. If we do nothing, it's job security for us, that's okay.
Right, but you get the consumer complaints. Mr. Weinkoop gets the consumer complaints, but nobody gets the dealer complaints when the violation comes the other way. When the consumer, someone comes in and says, yeah, just like Steve said, and they jump in the car and they drive to Florida and leave my car in Florida. Now, how do you collect on that one? Or they drive to Florida and drive back in 3 days, and here's your car with 3,000 miles on it. And we don't want to, you never get complaints like that. On the dealer side, now that's my responsibility, I spot deliver, and I continue to do that, would continue to do that. So, it's both sides of the fence. And I got no problem clarifying and overstating, no guarantees, whatever the verbiage has gotta be, but I also wanna make sure that there's something that protects the dealer a little bit. You never get those complaints, because we have to resolve those ourselves. So the consumer's got more than one avenue to go to try to get, in their minds, restitution, but the dealer's got no place to go. 9 out of 10 times, you just write the check, resolve it, and get on with it, and that's the cost of doing business. So, you know, you never see those complaints. You never hear about them. You never get involved in them, but they happen out there every day in the same kind of frequency, and maybe more than what you guys see. So, I look at both sides. I'm all for clarity. I love the idea with Michael's done as far as, you know, let's put in it doesn't guarantee. It won't change anything. But it's there, if that helps clarify something. But to try to think we're gonna take care of that 5% somehow, there aren't enough rules, regulations, and laws to do that, in my opinion. Clarification, I'm all for it. On both sides. You know, there's nothing in this form that says anything about miles. You know, someone jumps in a car, and like I said, I've had it happen. They went to Florida to drop Aunt Millie off and drove back, and here's your car. It was the quickest way to do it with a nice guarantee, and, you know, and I shouldn't collect something on that?
Oh, nobody's saying that.
No, I understand, but I'm
We've
saying,
never said that. We've always said that dealers have a right to bailment under certain conditions, absolutely.
for someone, you know, attorneys telling a guy, hide the car, no, I'm not saying you, I'm just saying, but telling the consumer to hide the car.
I don't think putting it in your garage is quite hiding it, but.
Well, putting the padlock on it and,
But just never driving it, it stays in the garage for years.
all I'm saying is that you see one side of it, and I appreciate what you guys have to go through, believe me. But there's also the dealer side of it that nobody ever hears about because he just resolves it, takes care of it, and moves on with life.
And that's the beauty of having this group debate those issues.
No,
So everybody understands.
and let's get more clarity, I'm all for it, because it won't change anything.
Now's a good time to take a 10-minute break. It's 5 after 2, let's come back at quarter after 2. Or, yes, quarter after 2.
Okay.
We're back, it's 2:15. We left the discussion off about the form and putting into the form some language about financing is not guaranteed. I think it's fair to say that some of us will never agree, ever, on when financing is guaranteed and when it's not, okay? But from a clarity standpoint, it sounds like most people want that in the form, right?
And maybe you put it in the form and you put a second signature line right next to it, more than an initial.
I want to get back to your question of, we're now more looking to put the required disclosure language in rule and not have a specific form, right? That was,
Tammy, I think what would have to happen if we take the form, if the form comes out, and the form is not the regulation. Okay? And I've never seen, I understand the reason it was done years ago, but we've never seen that anywhere that we've looked at.
You know,
The form is a regulation.
yeah, I think the regulation should have the required disclosures, not a specific form, and I think I'm in agreement with you, so just as we move along, that would be perhaps a requirement that we need to articulate, right, if there's 2 signatures or whatever, but it wouldn't be actually in the regulation.
The only thing I'd say for or against that, Steve, is that any more important than the other items on the form? I mean, is initial good enough for A, B, C, D, but we've got to have, you know, a signature?
You know, they've changed the Bradford contract. Now requires 2 signatures. I can't tell you what the new language was that was added. And it's maybe been a couple of years, because they wanted, and maybe it was the itemization portion of the retail installment sale contract now has a second signature. I'll research that and provide it. So, regarding whether the form's in 126108, parens 1, parens B, is the compensation disclosure form that broker transactions are required to use. And I don't know if that's the form. It does speak to the fact that nothing herein shall be construed to limit permissible disclosure to the information shown. So, is this a form embedded already? There is not, you're correct, there is not a, okay. So it is not a,
And I think you're right, the actual, it does show the form in the reg.
I'm looking at it right now.
Yeah, yeah.
Mary could probably give some historical perspective on it. It was my understanding, and I could be totally way off base because I wasn't here when that was put in, that they want those disclosures in that order, in that language, but it's not a specific form, whereas this is a DR numbered form, and the form's like
Right.
embedded into the regulation. Am I
Right.
wrong, Mary? You've got the historic. Okay. You've got the history way better than I do.
And so maybe this does speak to the fact that if this is not a form, we don't have to have the form embedded. It may be something to look at.
What's happening, Stephen, you sort of addressed this off the record with a comment you made last time about how we, when we redid our website, and we redid the way our website looked, and we separated the statutes from the regulations.
Right.
And how difficult that was for you going in the first time because you weren't used to that
Right,
format. Just a quick comment on that, and the reason I would like to see the form come out and not be embedded is that the way that the auto industry division promulgates and publishes rules, that the regulation is the same number of the statute, okay?
Right.
You're going on for forever,
Right.
is absolutely, I would say it's the only agency in the United States that does it that way. It's the old way to do rules. We have talked since we started about recodifying the entire regulatory, the way it looks, and grouping groups of things together that make sense. And actually, our legal assistant is working a little on that right now, and that's the way that every other state that we've looked at, I'm saying there's not something that we've looked at, does it that way, and all of our sister agencies do it that way. And so it's hard to get used to, though. It is a little difficult to get used to. But that's the new way, or newer way to do regulations. So moving from without, from underneath the statute.
Well, I think to your point, you guys, to fix just the contact information in the website at the bottom, it means adopting a whole new rule to
Yeah.
correct some minor things on the form, if it's not just limited to the actual disclosures, so, I would think there's probably general agreement on that. One question I have is, so if the rule just outlines the disclosures that must be present in the form or the contract, and it could also require that it's a separate form, not embedded in other language too, of course, but could the division still develop a DR 2343 form as well as allowing folks to have the option to do their own if they want? I still think it would be helpful to have an official form available, and most would probably use that.
I think it depends on how the board wants to operate, but I think Mr. McKinnon has an opinion that Mr. Weinkoop might not share, I don't know. And Mr. McKinnon believes that the statute allows that same language to be incorporated in the retail installment or the buyer's order, and not everybody likes that idea, but I think that has been done. by one of his clients, so they don't use the form at all, they're just required to have the same things.
See, and I think the rulemaking that happened 5-6 years ago, I think, made language changes that it used to allow for that, but I'm not sure that it does. But regardless, we're here to talk about what should it do, right? So, in terms of.
And go back to that 12.6.108, the compensation disclosure, it says the following form will be deemed adequate.
Right.
Yeah.
So it doesn't shut off using another form, it's just, here's a sample, you can use this.
It has to have that at a minimum.
Yeah.
That's a minimum, right, yeah.
And that's a regulation, Steve?
Yes.
So we'll tackle that, this group will tackle that in group 3 or something like that, but not.
Well, no, I mean, I think if this, as you go down this road, you potentially could address them both simultaneously if they need to be both changed or would be. Let's get plenty of time.
I don't know.
That's a whole other.
So how does the group want to proceed? You want to proceed with talking about that we may not have agreement on what the language of the form needs to say. And then next meeting, come back and look at what does the language of the reg need to say when we unembed the form? How do you want to proceed?
From my perspective, the central question is going back to, is a retail installment contract financing or not? And until there's agreement, non-agreement ruling, something on that, you know, I think doing the language of what the disclosure is kind of cart before the horse. You know, if this form is tied to just the buyer's order, and I have no problem with what Mike's saying, you know, put it in the, you know, buyer's order, purchase order, whatever, because I think that's where it goes. I think this form ties to a buyer's order. And then once you do a retail installment contract, E, F, and G aren't applicable. So, you know, to that end, I think that's fine. Figuring out the language on E, F, and G without making some kind of determination on whether a risk is actually financing.
It's
So-
financing that could be canceled, Rick, and that's as far as we're gonna be able to get. I mean,
Well, I think what
from the
Mike,
industry's
what Mike pulled out here on the actual statute, and the actual wording in this statute does seem to answer that question, and this is the underlying statute on these disclosures. And it refers to, except as otherwise provided in part 1, where the purchase price of the vehicle is not paid to the dealer in full at the time of consummation of the sale, and the purchaser, so it clearly contemplates that there's a consummation of the sale, and then it goes on to say, and the purchaser and the dealer elect that the motor vehicle dealer shall deliver, and the purchaser shall take possession at such time a statement that in the event financing cannot be arranged in accordance with the provisions stated in the contract, and the sale is not consummated, so the statute somewhat conflicts itself, as a matter of fact. Because before that, it says, at the time of consummation of the sale. And so, and I think at one point, I suggested rulemaking that referred to sort of like initial consummation and final consummation or something like that, because the statute uses consummation in 2 different ways. So there's really kind of an initial consummation, and then there's a final consummation when all the contingencies in the contract are met. I mean, that gets into a fair amount of minutia, but, and then it says, you know, shall agree to pay daily rate, mileage rate. So, but just the Colorado statute clearly contemplates that a sale is consummated and financing is not guaranteed, and the customer is gonna drive off with the car.
What's the statute,
Well,
Tim?
I mean, that's in the statute.
yeah, but the purchase price is paid in full with the retail installment contract.
That's
You've got a right to
12.6.104
payment. You've got that,
K.
when you've got that retail installment contract, you have a right to payment. So the purchase price is paid in full. It's, analogous would be, say you got a car accident and you're suing for your medical bills. You don't have to pay all your medical bills before you have those as damages. okay? The fact that you owe medical bills is your damages. Just in the same way here, if you've got a retail installment contract that you owe on, and the dealer has that contract, and you can take that contract and cash it somewhere, and it's paid in full. You can keep it yourself, and that's your right to defer payment that's considered under a retail installment contract. So, I don't think those are two necessarily separate things. When someone has a executed retail installment contract, that binds the consumer. That purchase price is paid in full.
And I would just argue the statute says something totally different, as has industry practice for years and years and years, and so, I don't know how we make a decision. Again, I don't know that we're going to come to agreement on that point. I think we have fundamentally different opinions on it. So whether we move forward and, put together what everybody can agree upon and move forward with that, and at a certain point, the Attorney General's office is going to review the rule, and if they think that that is not allowed under statute, they would advise accordingly. I'm not quite sure the best way to, and that would be one way.
I'm just saying, if you're gonna disclose to consumers what the law is, we ought to be clear on what the law is before you make a disclosure. I mean, we're disclosing, there's no agreement on what the law is. The AG wants to weigh in, or, someone wants to make a test case, I'll take it up. Whatever, but I don't know how you can do a disclosure, this is the law, if we don't have any kind of
Is
understanding
it
of what the law is.
possible for us to request a legal opinion on it? I realize that incurs expense, and to me, the only other alternative is to go through rulemaking, and at that point, the Attorney General's office takes a look and reviews the rules, so I don't know what the best way is to resolve that.
Within the power of a benevolent dictator, perhaps?
So here's what happens, here's what I fear. I fear what happened last time, okay, and I fear it again, is that we have such a disagreement on this specific issue that Mr. Weinkoop is talking about, and nobody's gonna move off of their position, I get that. So putting together, the division eventually has to put together a rule. We try to get as much consensus and so on and so forth. We try to put together a rule that encompasses all of it and is what we think should be right. And then that rule is noticed and published. And when it's noticed and published, then there's these blast emails come up and everybody can comment on it. Okay? At that point, up until that point in time, the AG's office doesn't have to weigh in. The AG's office has to weigh in after the rule is noticed, okay? Well, it's after the hearing, I believe, even. After the hearing, after the rulemaking hearing, then the AG's office and OLS weighs in at that time, and DORA gets involved in that, those kinds of things too. So, if we can't get to a certain point in there, drafting a rule at this point, what could very well happen is what happened last time, is when we do the blast email, that the rule is published, here's the way it looks, we're ready for public comment to make the record for the board. Last time, we've got a response from CADA, and we got a response in a different way than what your response was from, I'm just gonna throw a number out, I'm in the ballpark, 28 attorneys that disagreed with the way that the rule was sent out. And basically that this thing, it was all around the guarantee of financing and the down payment issue of 61708. So at that point in time, I realized, and then there was a request for a regulatory analysis under the statute. It was a perfectly legitimate request for a regulatory analysis under the statute within the timeframes. And I realized right then and there that the way that the regulatory analysis statute reads, there is no way the division could comply with that, because that is something that would take several weeks. We had 14 days. Several weeks for us to try to figure out the regulatory analysis. The economic impact, that's really what the regulatory analysis contemplates. just got off the phone on a different case that has exactly the same thing. New legislation is coming out, by the way, or the new legislation that is being considered. So that put a stop, so I canceled the rulemaking process at that point in time because it was just, it was obvious that there was nowhere to go with it. Number one is we couldn't put together regulatory announcements because we didn't have the statistical ability to do that. We would have had to send out probably surveys to survey dealers, we'd have to survey customers, how does this impact, so on and so forth. So I canceled the process. If we were able to accomplish the regulatory analysis, if we were able to do that, in my opinion, that would require an economist to look at it, okay? If we were able to do that, what would have happened is that the board then would sit at a rulemaking hearing, and we would have had to get a bigger place to go, because the debate on that would have been as furious as any debate we had here times 10. And so then we've got 9 board members sitting there thinking, what did Zuloff get us into? Because it would have been overwhelming. And being fair with the board, how do you make a decision when there's that many differences of opinion and very educated people making counter arguments on everything? How does the board make a decision on that? So I don't disagree with Mr. Weinkoop is that if there's still a fundamental issue here that needs to be tackled in some way before we move forward with changing something, are we right back to where we were the last time? And I just don't want, I don't want to waste people's time. I think if you don't get to the fundamental core of something, can you move forward and get to someplace? There is nothing that says that this rule, as it stands right now, has to be changed. There's nothing that says that. It says we have to review it. What I'm telling you is that we had enough concern a couple of years ago. I think your 5% is we had enough concern a couple of years ago that this needed to be looked at. And when we put out the blast email when the last one was done, there was a lot of concern with no agreement. A real big difference of opinion. So I'm concerned that we can't get past one area of agreement. And it is, could I ask for the Attorney General's office to give the division? Attorney General's office can't give this working group an opinion because they don't work. That's outside the statutory ability. Could I ask for the Attorney General's office to write an informal opinion on this? Yes, and Mr. Cherry would take a couple of his people in his area, and they would research it and write an informal opinion, and the division would have to pay for that time. Okay? It's okay. Could we ask for a formal opinion on this? Yeah, a formal opinion goes all the way to the top and would take a considerable lot longer of time because it really would. Right now, sitting here just kind of blabbing, I don't have the concept of what the best way to go is on that. I'm looking for input, but I think Mr. Weinkoop, and I respect Mr. Weinkoop enough to say I don't know that what he just said should be taken lightly. What he believes and what Mr. Donald and Ms. McQuigley, you're never gonna get together, and I understand it. And maybe there is some higher body that can weigh in on that issue. I don't know.
Well, I guess it would be my contention that, private attorneys can argue over every single word of everything, right? And the job of the state and the dealer board is to answer some of these questions and provide clarity in rulemaking so that industry and consumers know what their rights are. And I think that's critically important here, that we have to try to get answers to these questions. When I get a call from a dealer that wants to know what they have you know, do I have to refund this money, you know, can I withhold bailment? It'd be nice to be able to give a clear answer and have clear guidance on that question, and it's a fundamental question of legal interpretation. And, you know, in my mind, that's the role of the state in this, is to weigh the opinions, to bring in the Attorney General when necessary, and make a decision. And if folks don't like that decision, they can appeal to the legislature for a different policy direction. But that it's important to get some resolution on the question, because it is an important question when these
We
cases
have
arise.
opinions now. We get two opinions. So we can go to another group and say, okay, give me your opinion, and they'll give you just that, their opinion. So what's the final legal opinion?
Well, I mean, if the industry isn't going to make any efforts to go and resolve it, I mean, you're saying it's a 5% problem, okay? I'm saying it's a 5% problem that the industry already has a solution to. Don't trip the car to risk. I mean, there's already a solution involved. I mean, you know, you could just say, okay, great, we won't trip the car to risk. The disclosure form goes with the purchase order, and if we trip a car to risk, we give up our right to bailment. And so that's 5% and whatever percentage of that 5%. But the industry seems to want it all. Okay, we're just not gonna make any compromise on this whatsoever. I'm arguing against my best interest, personally. I mean, as far as I'm concerned, let's leave it as is. I'll keep making money, you guys will keep making money, we'll all be fat, dumb, and happy. But if the industry's gonna say, we want this percent of 5%, and we want that money in every case, and we're not gonna give up that bone, well, yeah, there's gonna be disagreement. There's absolutely gonna be disagreement. But you already have a mechanism in place that this doesn't have to be an issue. If you got someone with a 590 credit score, don't trip the car, all right? Or trip the car on a purchase order and say, you know what? I'm a gambling man. I'm gonna take my chances here. You sign the risk, maybe it doesn't work out, I don't get bailed on it. But they want to, you know, they want the cake and eat it too. Okay, I want to be able to trip the car, I want to be able to have an enforceable contract, and if I don't like what I can sell this for, if I go to Centrix or one of these third-party lenders and they want to charge me too much participation or too much discount or whatever, well, I want the option of unwinding this car deal, and I'm covered because I got this bailment money in my pocket. So no matter what happens in the marketplace, I'm covered either way.
But there's dealers out there now that don't charge bailment. They don't
Absolutely.
They don't even use the form. So
And I can tell you half of them.
But that's the
And
option.
generally speaking, I can tell you when the dealership's gonna start doing it, because I know the general manager comes from this dealership over to this dealership, and he's gotta get his numbers up. I can name you GMs that all of a sudden change one dealership from we don't charge bailment to we do charge bailment. Absolutely, but you don't have to. You guys got all the cards.
Well, I wouldn't say that.
You
The consumer
absolutely
holds a few
do.
cards too, so.
Sure, they can walk out, and that's what car dealers don't want. You want to divorce them. You want them under contract so they don't go down the street and buy something with a car dealer who is maybe less than honest than you, that says, you know what, we don't know if you're financed or not. So everyone's got to go to the bottom, right? Instead of being honest and saying, you know what, maybe we can get you financed, maybe we can't, let me call you Wednesday. Everyone's going to run right to the bottom and get them under contract. What they ought to be doing, take the high road, I'll call you Wednesday, or take the middle road and say, you know what, I don't know if it's financed or not, but we're gonna have you do this purchase agreement. Now, it comes with a cost, there's a bailment agreement that goes with this. If we can't get you financed and you wanna take the car, it's gonna cost you $200 a day. That's the middle road. The bottom road that you guys are trying to do is, we want the contract, we want the money, we wanna be able to keep everything.
No, I think what we're saying is we're trying to talk on behalf of 260 dealers, plus the number
Yeah.
of used car dealers in the state. And you're trying to talk on behalf of them and taking the consumer into mind. I think right now, we're trying to do on both sides of the fence.
Yeah, but, you know, the
You know, by
purpose
the
of the
same
dealer
token,
board
if
is
I'm ready to
consumer
walk out-
protection.
If I'm ready to walk out with a car and I have to go traipse back in again later to sign paperwork, I don't wanna have to do that.
I
You
know
seem
I
to
don't.
wanna dictate a decision that everybody has to comply to. I mean, this is a negotiation, this is an optional deal. The dealer has every right to protect themselves in the
Absolutely.
situation of spot delivery.
Absolutely. Trip it on a purchase order, not a risk. You're protected, you get bailment. If you're
They
confident.
don't have to do it that way.
If you're confident
They can sign
in
the
the deal.
deal and 95% of the time it's gonna go through.
Great, so we're arguing about the small percentage of the 5% that don't work out. If you're confident in the deal, if your F&I manager is strong, he's gonna go get that deal bought. Or you know
she.
what? Or she, whatever. Either way, you've got the money, you've got the contract. You don't want, you wanna take a
Bottom line
risk.
is Colorado's statutes already
Right,
provide.
and that's,
this.
and Rick,
it's
that's the
spelled out in
problem.
black
Your,
and white.
your position is inconsistent with what's in Colorado law now. I mean, the next.
And yet
if
somehow
we're-
I
and if-
keep
and
making
if
a
they-
living.
Let me finish, please. I sat here and listened to you for 3 or 4 minutes. You can do the same. Spot delivery is contemplated in the Colorado statute.
Yeah.
The model, let me finish, please.
I'm agreeing with you.
The,
What are you looking at, if I may ask?
104.
104.
It's contemplated here. Conditional delivery on financing approval is contemplated. The world that you're talking about is not in the Colorado statute. Let me finish, please. I know you're just dying to jump in, argue federal law and code of federal regulations and
No, I'm just
everything else.
asking, when have I ever said you can't spot deliver a car?
So the bottom line here is, we have a form which is inconsistent with your view of the world now. Right? The 2434 is
necessarily.
inconsistent with your view of the world now.
As
I
of
think it
now.
could be cleaner, but no, it's not necessarily inconsistent.
Okay.
I think the dealers are
So,
doing it
If
inconsistently.
we're gonna stop this process because one voice in this room disagrees with how this industry works and what the law is,
Or 28 other voices.
yeah, I mean, I'd be incredibly frustrated by that.
Well, Mr. Don Booth, I will tell you, myself and my division spent hundreds of hours on the last one.
Right?
So it is more than one voice.
Okay.
It's a lot of voices. So it just is, okay?
And
I don't wanna waste 1 minute of your time, but I don't wanna waste 1 minute of my time either.
Right.
And I'm not talking about a waste. This discussion is not a waste. This is a good discussion. There's nothing wrong with it.
Well-
What I'm concerned with is that if we can't get past point A, are we jumping to B and C? And I think that's what Mr. Weinke was saying, and then we are, then
Setting
at the.
ourselves up to fail at the end.
Yeah, I wanna set this up for the best chance of success we can.
And I
Really,
wanna
if
comply with
everything
the
he said
statute.
is true, then
Right.
the current form is a problem. I mean, if everything you're saying is true, the current form is already a problem.
Right.
Is or is not?
It is. I mean, if every time a dealer signs a retail installment sales contract, they can't charge bailment, and this is required on every sale, this is already a problem.
The current form, in my opinion, is a problem in as much as it refers to a contract, but it doesn't say what the contract is. And you've got a couple of different documents that can be interpreted as the contract. The buyer's order, the retail sales contract, or the buyer's order, purchase order, whatever, that's a contract, okay? The retail installment sales contract is a contract. Now, the car dealers always say this modifies the sales contract, but 104 specifically says that this thing can't modify a retail installment sales contract. Because whoever drafted that up realized in their wisdom that you can't modify an existing sales contract. You can't do it with outside documents. So it doesn't apply to a risk.
But we're gonna say, from our association standpoint, I wanna know, for our dealers, when he calls me and says, hey, your dealer charged bailment, financing wasn't approved, we have a violation. I wanna know, okay, why? Well, the thing is guaranteed financing. I need to know, what do I tell our dealers the division's position is with regard to guaranteed financing? That's the whole, I think that's the point of this thing,
Did
isn't
you
it?
guarantee financing and did you pull their bailment usage out of their down payment or deposit?
That's what I need to know.
That's the question.
Yep.
That
We keep
is
going
our-
around and around.
We all
That's
agree
what I
with
need
what
to
the
know.
question is.
And that's what I think what I'm
That's what
proposing.
we have to ask and find out, and with the existing form, with the language that it has, it is allowing for, we would investigate and say, yes, there's a violation, and you would go right back to our current form and say, well, you told us we could do it.
And that's what I
That's the
think
fundamental
what-
problem,
Yeah.
right So, there.
What I'm
So
proposing,
then
I
what
think,
you're
is nice.
saying,
It gives a
an
bright line
improved
rule.
form,
If there's a
yes,
risk, there's
would,
financing.
would help the consumer and the division.
I don't think
And
it's as
dealers.
difficult as we're saying.
I
I
agree.
think if you can put verbiage into whatever paragraph, if we want to restructure it.
Absolutely.
But you put verbiage in that says, you are not guaranteed, you're taking this vehicle now,
Right.
and the risk associated with taking our vehicle is 50 cents a mile, $50, whatever you guys want to charge. I don't want to get into that point, but then they can't come back and say, oh, okay, wait a minute. Well, they told me that it was all good, now they're telling me it's not good. They wouldn't have that good of an argument coming to us anymore.
I mean.
And take out the word that we can, you would be entitled to collecting bailment because you can say, we did not guarantee, and Tammy, we would be able to say, you know what, I agree with you. It's pretty clear here,
Right.
you didn't guarantee it.
Right.
But you're saying also, if we can insert, this is not a guaranteed financing, but you also want us to take out the ability to use down payment as the.
Well, I think if you clean up the guarantee part and make it as crystal clear as possible that this is not a guarantee, it erases this beef
And I
as
think
to
you
whether
have a
you are or
different-
aren't
And I think you
guaranteed.
have a different
You wrote
position
Yeah.
than Mr. Winku on that.
I don't
Like, I
think-
think you have a different position than he does on that.
And I've been saying for 2 hours,
But I
we
would
could
agree.
guarantee in.
I would agree with you completely, and I mean, I think that language is better, way better, and I'd love to see it in big bold letters, but I don't think that gets at the heart of the argument you're making at all.
Well, he'll continue to be able to go to civil court and argue that separately.
I don't wanna put them out of work.
Yeah, either one.
Appreciate that.
I mean, as hard as it is gonna be, there's a legislative declaration and duties of this motor vehicle dealer board that has to go down this road. And that's clearly in statute. And so, we may have disagreements, and there may be 28 people that will weigh in, but that board is gonna have to work through that and put a form, embedded or not, in place that they can all agree to, and go through that process, and then the AG and DORA and any other acronym will review that, and then dealers and consumers will have, and we'll met every statutory requirement.
But in the meantime, you can write a paragraph that says, in bold letters, seller does not guarantee financing, and put it in there.
And as long as you have that in a finance contract, I'm always gonna argue they did guarantee financing.
That's
That's
to be determined by somebody down the road.
Be able to represent clients.
Then why change anything?
And just like other areas of the
To
law.
put
we
the clarification that these people have to go through because it wasn't real clear to the consumer. I'm saying, let's make it clear by saying this is not guaranteed financing. The technical part of it that you two and probably others will never agree on, somebody else has gotta make that decision, that's not us.
Okay, when you say this is not guaranteed financing, what's this?
It's a mute argument, Rick. D, legislative declaration, consumer education concerning the rules and regulation of the motor vehicle industry, the considerations with personally a motor vehicle, and the role, functions, actions of the motor vehicle dealer board are necessary for the protection of the public and for maintaining the trust and confidence of the public in the motor vehicle dealer board. It's the ongoing consumer education.
All we're saying is that there's not a guarantee of, in bolder letters, just like in bolder letters, we're saying that within 10 calendar days. I mean, it's the same thing, it's just making the
Let's say-
consumer more aware.
Let's say you've got a retail installment contract that doesn't have a seller's right to cancel on the back. And you've got this bailment agreement that says this is not a guarantee of financing. And you've got an unconditional retail installment sales contract. Is there a guarantee of financing? That's what I'm saying. You want bright line, you want certainty. The answer is, there is financing if there's a finance contract. That's the bright line. And to keep arguing over, we want to keep, some guy's $1,000 down payment because it happens 1 in a billion times. And I think it's silly, but, we can spend as much time as we like on it. But that's the bright line, easy rule. Trip a car on a purchase agreement, you get bailment. Trip a car on a risk, you don't get bailment. But that's real simple.
The difference gonna be is, for our purposes, we wanna know that the AID says, whatever the language put in there, we don't think you guaranteed financing, so therefore, you can go ahead and take the down payment, there's no violation. For a judge, if you wanna argue to a judge or an arbitrator, that, I get it, we keep you in business, okay? I may not agree with the bailment part of it, but I just need to know for our members, when AID knocks on our door, why can we go ahead and say we didn't guarantee financing and why we went ahead and were able to keep part of the down payment? Matt's got the solution.
That's already said it real simply,
Right.
it'll make it easier for them, clarify it better for the consumer, and the two of you, will worry about that in court.
Because here's the
5 years
problem,
down the road.
you can take that disclaimer and you can put it in neon, all right, it doesn't matter. What you're effectively saying is, as long as there's a signed bailment agreement, there's never guaranteed financing. It precludes any option that anyone was ever financed. And then you run into the 61708 thing, which talks about any document or oral statement that would lead a reasonable person to a good faith belief that they're financed. So, just putting a big disclosure in there, no matter how many point types, put it red, whatever, is not gonna change that. What's gonna be bright line and easy is, Matt's gonna call you up and say, well, did you sign a retail installment contract? Yes, we did. Okay, then you guaranteed financing. Calls up and says, did you sign a retail installment contract? No, we did not. You did not guarantee financing. Done and done. I mean, that's the simple.
But that's your
binary
opinion.
thing.
That's one opinion.
That's my speculation. That's not even opinion.
But
This is gonna be the easy way to do it.
We've got 40 years of other contracts that's never been an issue.
Oh, okay, so we've always done it that way. That's always the way it needs to be
Good
done.
enough for me.
Well, and, to your point though, I think it's a fundamental point of dispute that could go to the dealer board. If the dealer board agrees with that position, they could decide to adopt a rule that says that a dealer cannot charge bailment if they've signed a retail installment sales contract. I mean, the board could decide to put forth a
Absolutely,
rule
I put that in the
and
instructions
make
on
that
that.
policy decision. I'm not even sure putting that in here is really even authorized under the statute that calls for this disclosure form, frankly, because it's a completely different mandate in my mind. To me, I think the language that is problematic is the one that says, dealers shall promptly return deposit, including any trade-in vehicle. And that, if that's on this form, then that's problematic. That's an issue, I think, to what you're saying. We can have some clarity and we can provide some disclosures and we can try to make it as clear as possible, but nothing's gonna stop a person from alleging that there were oral representations made that led to their belief that it was guaranteed, and they can hire you and file a lawsuit, and we can't change the Deceptive Trade Practices Act. I mean, that's not gonna go away, and everybody that has a dispute is probably gonna argue that they thought that it was guaranteed, regardless of what we put in the form. All we can do is try to make it as clear as possible.
I can tell you if someone comes and they don't have to sign a retail installment contract, and they just say, well, the dealer told me I was financed, I'm not taking that case. Your word versus the dealer's word, and there's the thing that says you're not financed. But if they come in with a signed retail installment contract, yeah, I mean, that's an entirely different thing. You understand, I'm not gonna take the case as just your word versus the dealer's word. Oh, and they've got the disclaimer. They gotta come in with something else. I'm asking them, did you sign the contract? Did you get a temp tag? Did you get a registration? Right? They took you off the lot. Did they keep your money? Did they cash your check? These are all indicia of a sale, like what Bruce was talking about. Did they, did you insure the vehicle? Right? Why is anyone gonna insure a car dealer's vehicle? Right? And technically speaking, under insurance law, I don't think you have an insurable interest in any way in it. So I don't think you can insure a dealer's vehicle.
That's what constitutes transfer. That's a whole other argument. How do these contracts pass the smell test, for lack of a better term? That recancelable, Reynolds and Reynolds.
Reynolds and Reynolds is still I don't know if they're still issuing, but I can tell you dealers are still using an arbitration contract out of California that the California court has said is illegal. And I got one 3-4 months ago.
That's California.
Yeah.
These contracts that are regulated by the banks and they would be just as culpable if they were accepting assignment of a contract that was not enforceable or illegal. They wouldn't cash them. They would never let us assign it. No, that does not meet the statutory requirements, federal, state, or otherwise, to be used.
Contracts are found illegal all the time.
Well,
I mean, I don't know what you want me, then we should just disband. Why are we even here?
Because we have.
Because Bruce made it.
You guys can all leave, we have to stay here though.
Actually, it was really the governor, because he called for this.
Yes.
And,
Yes.
and Mr. Kennedy, you're not getting paid until you get the job done.
You always threaten to sell.
All right, here's what I'd like to do. I'd like to take a real short break now, because it's close enough. I'd like to come back for about 15 minutes. No more than that. I don't think we're gonna, I have a couple of ideas moving forward, but I need to formulate them in my mind. Let's take 10 minutes, come back, we'll be out of here in about 20, 25 minutes at the most.
Can you bet on that?
Sure.
Chris wants to bet on it.
Okay.
Okay, we're back on the record. It is 3:10. Let me see what the group thinks of this. For those of you that feel compelled, and I would hope to get something from CADA, CIADA, from Mr. Weinkoop, and perhaps Ms. Marvin. Some wording on E, and perhaps D. And that's it. And and I'm gonna pick a day here, we're gonna look at calendars for a second. Then what I would do, and I would like those by a date specific, then the division would take the next step. And the next step would be, this is a rule that from the start, I contemplated that the Attorney General's office would write for us. And I'm not backing off of that. So anytime you get the Attorney General's office involved on the front side, at the very back side, it's better because they are all up to speed. Have the AG's office draft this rule, and also the changes to the form, unembed the form. I think we all are comfortable moving towards unembedding the form. And then, and have Mr. Heap work with the AG's office on that issue because, you know, he's the golden-haired child here today, so, you know.
He's got a lot of time, too.
Yeah, he's got tons of time.
This is all I do.
When you're not sitting around and we strike mistakes.
And then kind of get that rough draft form and send it to everybody for the next meeting. I would also like Mr. Weinkoop to, if he could, he said it, and it's probably on the recording, but if you could put together 2, 3, 4 sentences on what the core concern you have is. Because you said it in 2 or 3 sentences, it was very well said, you might have to go back, but if you could put that in, so we could have knowledge of that in sort of in writing what you think the core issue is.
To allow the AG's office to look at that while they're doing the front end work to see.
Absolutely, absolutely.
We pull a lot of weight with the AGs.
Before Mr. McKinnon left also, he said that other nations in this state does not use.
Correct.
And they've got a complete disclosure on the back of their contract that takes into consideration all the discussions. I asked him to get a copy of that to you, so we could take a look at that. That could be a resolution also, falling back to what you were saying.
That's something like that.
So if everybody would do that, so I'm asking everybody that kind of giving everybody homework. If you could do that sooner than later, we'll get a date. Then we will take the ball for a period of time where you can take a deep breath and we will look at that, get the AG's office to do some of that drafting and then send it out before the next meeting. And then the next meeting we'll have another discussion. Knowing that we will have some disagreements too, okay? What's everything of that idea?
Great idea.
I like it. Okay. All right, so calendars. Here's what we need
Can I throw out just a couple other issues
Sure.
to consider in all this, and one of the open questions all along that I think is a little, is just whether this applies to a lease as well as a sale. Because they can fall through as well, and right now, it's always been, my understanding is when that change was made 5-6 years ago, it then only applied to sales technically, but not to leases.
Yeah, there's
And
change
just-
in the
Yeah, the-
federal law.
The disclosure box, the Fed box on a lease disclosure, which is federally mandated, and it eliminated the, at that time, based on rulemaking and the process, that lease disclosure was no longer required.
One,
Right, yeah.
our particular disclosure isn't really related to federal requirements anyway, and so there,
Right, but it came
my,
out of.
oh, that, you're
it
saying
just
that's the
came out
reason
of-
our regulation changed?
Yes,
Okay.
yes,
Okay.
when Reg M modified and put that lease box, it's a standardized disclosure box on any lease contract regardless of the manufacturer. Division, board, whatever, decided that they could eliminate the lease disclosure. 'Cause it-
So I guess in my mind, it is an open question, it would be nice if it was clarified in the regulation that we do finally adopt here, to make it clear one way or the other.
That it either does or does
That
not.
it either does or doesn't apply.
Right.
I mean, now you end up
You
kind
get
of,
any complaints along that line?
no.
No.
I know
One
it
in the
can,
last, like,
I know it can happen, and, you know, there are some, and really getting away from the form helps some, because there are some disclosures on here that are relevant regardless of whether it's a sale or lease, but leases can, I mean, it's still a form of financing, it still can fall through.
Okay, good point. The one other thing we haven't talked about is the other, we really focused on the form. And if we unembed the form and then write a regulation and keep a form in some manner, but we still haven't talked about the rejection of financing regulation, which is. V, yeah. We have actually had some, I don't know, complaints, probably a few, but we've had some questions about what does this really mean, what does it, doesn't it mean? And I think we have bantered with Mr. McKinnon a few years ago, because I think the statute talks about acceptance and or rejection, and the regulations just talked about rejection. Should a consumer be, I'm not just raising the question, should a consumer be notified of acceptance too? Or is that just assumed? Okay. You might have an argument on that.
Again, this goes back to what I'm saying, you don't have to notify someone of acceptance or rejection if there's a risk. I mean, that's just nice and clean. You know, if you're gonna go on a purchase order, yeah, it's, you know, do we reduce this to a finance contract? But if you got a retail installment contract, you're accepted. Obviously, you're accepted because you're obligated under the contract.
Well, we've had some questions on that, and Mr. McKinnon and myself and Ms. Rouse discussed this a couple, 3 years ago on a case, so. So there was one case that it really did play into that. The other thing is this whole issue of how long does it take? I mean, the board bantered this around some time ago, and is it 10 days now or 7 days? I don't know.
10.
So it's 10 days now. And if it needs to be
10 calendar days.
10 if it still needs to be 10 calendar days, okay, but the but is the unscrupulous dealer that left somebody in the car to eat up the bailment when they knew on the second day. And those are the cases, John, that we really need, the renting of the cars
Well, and, you
situation.
know,
So,
in my mind.
let me
Oh,
just
okay,
say this
sorry,
and then
sorry,
I'll.
sorry.
So is 10 days still okay? I think there's some people that thought it should be longer than that, honestly. Maybe up to 20 days, and there's some people that thought, wait a minute here, in this day and age, and I think, Steve, you said, sometimes you know in a matter of minutes. So the division doesn't have an opinion on this necessarily, but the thing that we do have an opinion on is if we leave the time frame in the disclosure, that it should be the same time frame as the regulation V. I think that if you marry those up consistently, it needs to be.
And what's V say?
10 days, 10
Yeah,
calendar.
I say leave it at 10, yeah.
So that's another issue we haven't talked about, okay?
That sounds like it's solved.
Yeah, just leave it.
That'll be easy.
Wait, seriously?
We really, we're all in agreement, so I'm like, whoa.
So, I'm sorry, now.
Stop now.
I think it should be longer.
Well, I think you can.
No, and I'm serious, and I'll tell you why. Consumer comes in to buy a car, he provides proof of employment, lender comes back and says, I can't verify this guy's employment, he needs to give me some pay stubs. Dealer calls consumer, says, hey, I need your pay stub. Consumer doesn't bring it in for 20 days. My advice to the dealer in that case is give him the notice that he's canceled within 10. I mean, but that happens, that happens all the time.
That's the 1% again.
Yes.
You can't manage by one.
And I say that, I'm dead
And you're
serious, I
right.
think it should be longer than 10, because frequently the issue with conditional financing is on the consumer side. But,
And the unscrupulous dealer, if you extend it, could, you know, go the other way.
right,
Tell you, the
play with
more
that.
money you put down, the longer a dealer will try to find the signee.
Oh, that's bunk, and you know it.
No, it's true.
Bunk, that's B-U-N-K.
They put $1,000 down, they figure it out after for about 10 days. You put $4,000 down, it's gonna be a couple months.
That's that 2%
An
of the
unscrupulous
dealer body.
dealer.
I don't scrupulous dealer.
Yes,
Yes.
that goes with the unscrupulous customer. They're both 2 or 3%.
But that's who this reg's for.
Right.
We write every rule for the 2 or 3%.
Look, that's, all laws are written for the 2 or 3% of folks that don't
Right.
follow the rules.
Hey, laws against murder are just for murderers, right?
Yes, yes.
And the other thing I was gonna say on that is just conceptually, you know, you could have a hard time frame, or, you know, within, you know, a number of days after the dealer's notified, something to that effect, you know, you could contemplate language that allows for various scenarios. It's not as easy as bright line 10 days, but it provides a little more ability to deal with different situations.
I think most of the time, when you get a notice of one way or another, if you get a notice of a decline, the dealer's not gonna sit on it, contrary to popular belief.
No, but I think what.
Because you wanna get it resolved.
Well, I think
mean,
often what happens though, and I've had these calls where we've been working with this guy for 4 weeks now, and both sides are kind of doing it in good faith. The dealer's continuing to, again, maybe not always, the dealer's continuing to try to talk to the lender, get what they need, they're trying to play intermediary, or maybe they're trying another lender, and they're even in communication. And then, of course, the next question is, well, right, okay, you talked on the phone, but did you provide something in writing saying that financing couldn't be obtained within 10 days? And it, you know, in some cases, it's just the dialogue continues. And that's where, you know, maybe it could be triggered by rejection, and maybe there's a way you kind of continue the process with additional notice that reminds the consumer that bailment charges may apply. And maybe that's a way that there's an extension of time in certain situations if they do X, Y, and Z, or you know, provide the an additional disclosure form.
Or another form.
I don't know. I mean,
Contain your enthusiasm.
Well, in today's world, you know, I don't let any of that dialogue stand. If we have to have written, communicate, email, text, whatever, that we.
Once you talk to them, I mean, it's gotta be
It's,
documented.
yeah.
but even then, does that
absolutely.
constitute written notice that financing could not be obtained? You know, is that sufficient?
Depends on.
Depends who your attorney is.
Okay, so, any more comments? So what I would like to do, and this is against what I really wanted to do with this group, I wanted this group, I figured this group, I had conceptually thought that this group would need to meet 3 to 4 times before we got to some kind of thing that we could then, the division could eventually push out the notice, and then all the debate starts all over again. But this stakeholder group, I thought, would meet 3 to 4 times. And in doing that, I wanted to meet try to meet every other week. But because we're going to take on a little different form in the second week is our board prep week, the third week is our board week, so, and I think we need a little more time. What I think I would like to do is try to set the next meeting and then back up to see what all of you take to get us some language that we talked about. So I'm looking at the schedule for this room right now. Morning or afternoon works better for who? Is there a, okay.
Well, you don't mind, Lisa.
I'm with
Depends
Dan.
on the day.
7:30 a.m.
Right now, there is nothing in this room. And this would work, I think this would work for us, and I think this would give the AG some time to work on this project after we get with them and get them your suggestions. There's nothing in this room on Tuesday the 24th.
Best day ever.
Love your
Let's
enthusiasm.
do the whole day. I have not, it's the only day I've got all month that I don't have something done, so.
Mr. Donnerman, Mr. Weincoop,
Yeah, good.
I'm good.
Good.
Mary, no training scheduled that day?
Oh, actually, no, I'm out of town. February 24th, I'm in Canada,
Is that fishing?
skiing.
Skiing?
You know you live in Colorado.
It's a long story. I've never skied anywhere but Colorado, Rick, but this is a special event.
New
I
horizon.
hate to not have you here. I guess that would be up to you and Ms. McCoy.
It's up to her, yeah.
She'll put you on the phone?
So is that the
You're gonna
first-
lose a voice of
What's the
reason.
next date? I mean,
Well, that's the day that it's
Okay.
totally free.
Okay.
Let me look at this next, are you out that whole week?
No, I'm back on Wednesday that afternoon, or that week.
Well, even that week prior, like the Thursday? or-
Well, I'm a little concerned, well, I know this room is taken.
Right.
I'm a little concerned that we may, I don't want to shortchange, I honestly don't want to shortchange the division first, but I don't want to shortchange the AG's office either.
Oh, and you're gone the week before?
So the next day's the 25th.
You're out the whole week, right?
No, just out Monday, Tuesday, and Wednesday that week.
Okay, so Thursday, let me see, there is something in here, but let's see when it is. Taxation training. They're here, pardon me?
Yeah, it's like we could do.
Well, they're here in the morning, they're here from 8 to 1.
Perfect.
Which would, I mean, right now I could book this room from 1 to 3 or 1 to 4. Now, that would be Thursday.
That'll work. I'm out of town.
You notice how none of the state employees are ever out of town.
Yeah.
Certainly not skiing in Canada.
Yeah.
When you have the 26th as a dealer board hold day, is that for this purpose or?
Was that for these type of? no,
Yeah,
that was-
you
You
had
know,
originally had it held, but I think you said wait until March.
You
and
know,
you
but I
were
think
released
there
in
may-
February, but there might be a hearing.
I think Leland might have scheduled a hearing. that
Yeah.
day. Actually, I think Whitey might have scheduled a hearing.
There might be a hearing that day.
26th is probably out.
Pretty good.
Are you out the 27th?
Yeah.
But yeah.
Seems like a lot of.
So we're back to the 24th and we would lose Mr. Donovan.
Well, or Mike, could you be on the phone?
Why would you really?
I have a friend who lost his leg to cancer. He's going up to Canada to learn how to ski on one leg, and I told him I'd come up and laugh at him fall. So, and,
What a guy.
Is
so,
it
and I'm
two
not
months
gonna,
till like
I'm
the
not
first
gonna
week
spend
of
3 hours
March,
on the
or-
phone
No,
arguing.
no, no.
Well, I just pulled up the first week in March, and right now Tuesday and Wednesday are open, which would be the 3rd and the 4th. Sorry?
I'm in trouble.
3rd and the 4th, okay, that's out. That whole week?
No, I mean, it starts on Monday, probably go 3 days, probably done Thursday or Friday.
Yeah, Thursday the 5th, this room's taken. Wow, I hate to put it off too
Yeah,
long.
much better than that.
Friday
Is
the
there,
6th.
Friday
Friday the
is-
6th, I am.
If the problem is the room, I can host.
No, I won't. I will get the Chiefs meeting.
No, well,
But I can see now, yeah.
I think under this current regulatory, scheme, we need the state needs to host these meetings. I think there's that.
Just offer.
Yeah.
And was Friday the 6th out?
Friday the 6th is out, yeah, the division can do that.
You don't really need me if I'm on that 27th or 6th.
Well, I think this room is taken, I think that hearing happens that month, so.
We really need you, Mr. Perkins.
No, there's 3 more years of this, come on.
All right, so what about the week before? Boy, I don't like the week before, but what about the week, I mean, that could really, we have a dealer board meeting on the 17th. You're off.
I'm gone the 18th, 19th, and 20th.
Yeah, that ain't gonna work. I gotta tell you,
We may just have to go back to we may just have to provide.
Can we just do the
comments.
24th?
Yeah. We may just need to do that, yeah, looks like it.
24th?
Morning, start at 7.
All right.
Oh, wait, I just realized I'm out of town.
So what we could do, for Mr. Darman,
Yes.
obviously, when are you leaving, Mike?
I leave Saturday the 21st and I'm back Wednesday the 25th.
Well, if we would schedule it for the 24th, you would no doubt get all the documentation. I don't know that you'd get it in time to make a bunch of written comments to it, but we could try to get everybody the documentation on the 17th or the 18th. I mean, what is the draft?
Sure, I'm here at CADA's request and on their behalf, so whatever they want with regard to my participation or non-participation on the 24th, I'm fine with.
You know, I mean, we'd love to have it here, but if we can't find a day that works for everyone.
I'll
then
substitute,
we
you
need
can
to-
just pay me.
Yeah.
All right, here we're gonna do the
Actually,
24th.
So-
Huh?
I mean, to some extent, I think a lot of it after this juncture is going to be written comments, frankly, related to the wording.
So are we on the 24th, 7 a.m.?
24th at 1 p.m.
It's only morning.
Shut up, John.
I'm picking them for you.
I'm getting, just seems to be a consensus here. 24th at 1 p.m.
All right, just make sure I get this thing done. 2/24, 1 p.m. VID stakeholder meeting, group 1. Okay, so I've got this room reserved. What I'll do later on this afternoon or tomorrow, I'll go back into this reservation and I'll do a group invite again, so hit your calendars.
And
Okay?
you wanted comments from us by a date certain? right?
Yeah, let's see, okay, so today is, for all practical purposes, the last day of February, okay? So can we have comments into us? Could we have comments into us by the 11th? That's a Wednesday. That will give, and those will be part of the record, obviously. Do you want me to turn those back around so everybody sees everybody's comments? And I'm okay with that. I can turn those back around, okay? So you'll see everybody's comments, and then the next thing you will get is you will get something from us on like the 18th which is rough draft language, okay? We're okay with that?
Perfect.
All right, tough subject, tough subject. Thank you all for your participation. Even though we disagree on a lot of things, it's a good debate. It really is.
And just to clarify, do you want comments, are we kind of limiting everything to the paragraph?
D&E.
D and E, no, we're not getting into comments on the 10-day rejection of financing part at this point?
Well, if you really feel compelled that you need something different, I didn't hear that from the
Oh,
rest.
no, I'm just.
Can rulemaking change V now? Are we, is this rulemaking broad enough in scope to change V?
Yeah, it's one of the ones that we're looking at.
Okay.
I mean, part of the purpose here is to recommend it.
What I would like to do is just get
If
comments
needed.
on D and E,
Okay.
and then what I would like to do is allow us the benefit to look at how to word the regulation with obviously the AG writing that, changing D and E, and then send it back out to you, and then we'll debate one form, one regulation next time. It'll take some debate, no doubt, so.
You wanna know the good news about all this? Rick's never gonna be happy with the new form, so he'll continue to be gainfully employed. He won't have to become a car salesman again. And then, when he goes to a court case, some good dealer will subpoena Randall and you and everybody to testify on the process and the AG's up front and back end, and how they say that this in fact follows the statutory language, and it'll be good.
Life is good.
It'll be subpoenaed, life will be great.
I consider the possibility, I'm just here so they can say I was inside the tent pissing out.
Better than missing out.
All right, thank you all, appreciate your time. Thank you.